Hello and welcome. My name is Jeremy Glover, and it's my pleasure to introduce our first Fenwick Elliott webinar for 2025. It's still early in the new year, particularly the lunar new year, and as it's traditional to look forward at the beginning of any new year, we thought we'd look at the prospects for ADR, in particular adjudication and dispute boards. And I'm really pleased to be joined by two highly experienced experts in these fields, both of whom have been working closely with King's College London. My colleague and fellow partner Claire King is recommended as a global leader in construction by Who's Who Legal and for international arbitration in Legal 500. She's also been on the steering committee overseeing the research on adjudication that has been carried out at King's over the past 3 years. We're also joined by Raquel Macedo Moreira. Raquel is a research associate at the Centre of Construction Law and Dispute Resolution at King's College London. She's a dual qualified lawyer admitted to the Brazilian and Italian bar. She's also the co-author of the report that came out at the end of last year looking at dispute boards, a project she'd been working on for at least the previous 12 months. I should of course say that Professor Renato Nazzini, soon to be Professor Renato Nazzini KC, a well-deserved honour, led both research projects. So just a reminder, you're all on mute. Please do feel free to send any questions you may have, and a link to the slides will be put in the chat at some point during today's webinar. But as a starting question for you, how long have dispute boards and adjudication been around? Maybe much longer than you think. This year, 2025, marks the 50th anniversary of the first dispute board, which was part of the construction of the Eisenhower Tunnel in Colorado. And it came about partly, it was a project in 2 bores, and the first bore was such a financial disaster that the Department of Highways were looking for an alternative way to try and move forward, to try and enable their project to move forward without disputes. And so the second bore provided for a review board to make recommendations which couldn't be settled at a job level. And the second bore, where they had the dispute review board, was a great success. The Department of Transport have paid out some 50 million US dollars in claims on the first time. The second time round, there were 2 or 3 very small claims with a value of about $250,000 in total. And as for adjudication, well, no one really knows how long adjudication has actually been around. In the UK, people think that the first adjudicator may have been Robert Hooke. He was a scientist. He was also an architect who collaborated with Sir Christopher Wren in doing much of the reconstruction work in London after the Great Fire. And one of the things he would do was adjudicate on disputes. I don't know, we're talking about costs later, but a fee of 10 shillings some 400 or 500 years ago is actually a lot more expensive than it actually sounds. But that's just, you know, the history. It's interesting, but much more interesting is the research that's being carried out into adjudication and dispute boards. And one of the issues that interests me is how effective dispute boards and adjudication actually is. And I suppose I mean by that, how effective are they in avoiding disputes? But this is just one of the many areas that the research has looked into. So I shall leave you in the capable hands of Claire, but first of all, Raquel.
Thank you very much, Jeremy. Thank you for this introduction. It's a pleasure to be here and to be able to talk a little bit about trends specifically in dispute boards, and then we'll hear Claire on adjudication. Before I talk to you about the trends in the dispute board, I want to give a little bit of context of this report on which we worked at King's. I am one of the authors together with Professor Renato Nazzini. It is a 160-page report on data obtained from the use of dispute boards. I would actually be very happy to discuss all those 160 pages with you, but unfortunately, we don't have the time for this. So I focused on some key results that we obtained, which I would like to present to you today. Before I go into the results, again, on the context of this report, we had a first very hard task, which was, what are we going to consider as a dispute board? So we decided to adopt a very broad concept of dispute board under the assumption that in different places of the world, dispute board means different things. They have different names, they have different practices. So for the purpose of all the results that I am going to share with you today, dispute boards were considered job site dispute avoidance and or resolution mechanisms constituted by individuals that operate independently from the parties to the contract and with the purpose of addressing the disputes of a specific project. So what we did in this report is we prepared 4 different questionnaires, one to individuals that participated in dispute boards, one to entities that were party to dispute board proceedings, one to institutions that may have been appointed or involved in the constitution or functioning of a dispute board, and a 4th one for funders, financial institutions that finance projects for which dispute boards were considered. All the questions we asked consider dispute boards that took place or were implemented from 2018 to 2023. So 6-year span in this case, because we wanted to see if the pandemic had any influence on the data that we obtained, and also to obtain an overview of the data that we were gathering. So just some numbers about the report that we published last year: 6 years of dispute board practice, over 12 months of research. There are 173 graphs of information collected, 213 respondents, 307 questions asked, so you can imagine we even got some critics about this, and 4,019 dispute boards reported. I have to do a disclaimer here before I proceed, which is these 4,019 dispute board reports mean 4,019 perceptions of dispute boards, because we cannot exclude, for example, that a party to a dispute board and a dispute board member in that same dispute board provided their opinion on the functioning, the usefulness, and everything that was included in that procedure. Still, we do consider that over 4,000 perceptions of dispute boards are quite a high number and can give you an overview of what dispute boards have been doing, how they have been happening all around the world in the past 6 years. Sharing some more details with you, I realized that the letter on this slide may be a little bit small, but I'll guide you through it. One of the questions that we asked all of these respondents was, what was the cause of the dispute that was presented to the dispute board? The majority of the respondents in this case, and I bring you the answers from the individuals specifically, so 42% of the individuals responding this question said that the major cause of dispute was changes by clients. The second cause of dispute ranked with 30% indication was clients' lack of information or decisiveness. And the third one with 27% was inadequate contract administration. This provides an overview of issues that someone working in a construction project can focus on, because this is reported to be one of the major causes of issues that tend to go to dispute boards. We also asked the respondents what were the categories of the claims. So once the claim arose, what were the parties asking before these dispute boards? So here, the vast majority that we have, 84% individuals reported that they fight before the dispute boards for extensions of time. They bring those issues to the dispute board. So that is the major expertise that is required by dispute board members to deal on extensions of time requests. Second place, we have 52% of loss and expense and or damages for delay and or disruption. And third, with 34%, hardship, force majeure, or unexpected events. Those were the most frequent categories of claims brought by these dispute boards all around the world. We also asked a lot of questions about costs. If you're curious about the categories of the questions that we ask, you can go look at the report. We have different sections for it. Costs is one of the sections. And we asked a lot of questions. How are the costs calculated? Who determines then? How much is the individual fees? But one specific data that I wanted to bring with you is the average total cost. We ask how much are these dispute boards costing the client. And what we can see here, in this case of the individuals, is that most people in this case, the response that was most selected was between $100,000 and $200,000. All the questions that we asked were in dollar currency. We also had 23% of the individual respondents who said between 50,000 and 100,000, and 17% who says less than 50,000. So while this may provide an overview of how much dispute board costs, I have to say that this specific graph has to be looked at with a certain caution. That is because the value of project can be completely different, which means that if I spend $100,000 on a project that costs 1 million is one thing. If I spend $100,000 on a project that costs 100 million is a completely different thing from the perspective of the client spending this money. And so the subsequent question that we asked was, what was the percentage that the dispute board cost represented vis-a-vis the total cost of the project? And I find these numbers to be very interesting. Most respondents, again, individuals, but in the report you can find the response also for entities and the other respondents, 55% of the individuals said that the cost of the dispute board usually represents between 0 and 0.5% of the cost of the project. Now, one person may think, this is still a lot of money. But again, this has to be looked against how much money a dispute board may be saving your client. Because resolving a problem at the end of the day in a construction project is saving money. So I find this data extremely important to demonstrate the actual value of the dispute board in this case, when combined with the next thing that I am going to show you, which is how effective dispute boards are. Because obviously a party would not want to spend money on dispute boards if they are not getting the result of actually avoiding or resolving their disputes effectively. So let me show you some more data about how the dispute board has been working in the past 6 years. The first thing that I want to show you is the answer to the question, how often did the parties comply with non-binding recommendation of dispute boards? So as you may know, dispute boards, depending on the rules that apply to the procedure, they may issue a recommendation, a non-binding recommendation, or a binding decision. So the first question that we ask regard these recommendations, the non-binding decision, how often are parties complying with this non-binding decision? And in the 26% of the individuals in this case said always, and 40% said most of the time. Still, as you can see in the last bar of the graph, 13% said that parties never comply with non-binding recommendations, which still leaves this answer on a positive note, showing that non-binding recommendations are still relatively complied with by parties through a dispute board. But we asked the same question regarding binding decisions. So we said, how often did the parties voluntarily comply with binding decisions? Again, as you probably already know, dispute boards' decisions can be complied voluntarily or later on enforced. We have information on our report also about the enforcement of the decisions, but in this specific graph, we were looking at voluntarily compliance. And here, 32% of the individuals said that parties always comply with binding decision, and the majority, 38%, said that parties comply with binding decisions most of the time. Again, this is a positive note to show that the decisions that are being issued by the dispute board are more often complied with than not. And that is regardless of their nature, regardless of the fact that they are binding recommendations, sorry, binding decisions or non-binding recommendations. A subsequent question that we asked the parties was about the effectiveness of dispute resolution in the sense that we wanted to know how often was the dispute board decision referred to a subsequent litigation or arbitration. Very often in construction legal frameworks, the dispute board is inserted as part of a multi-tier dispute resolution mechanism. So you have different layers of procedures that a party can resort to when approaching their dispute, which usually end in either a litigation or an arbitration procedure. Very interestingly, we discovered that 60% of individuals reported that only between 0 and 10% of the time, the dispute brought before a dispute board was referred to subsequent proceedings, which means that this dispute was finally resolved by the dispute board. There was no need to go further to fight for that same issue in subsequent proceedings. This number, 67%, we find it a very high number. Of course, it can get better, but it shows the effectiveness of dispute resolution from dispute boards. Considering these cases, as we've seen, few cases in which the dispute actually is brought to a subsequent level, so that the dispute is actually brought to litigation or arbitration, we asked, how often was the decision of that judge or that arbitrator substantially different from the decision of the dispute boards? And again, this is a positive data because we got 44% of individuals responding that it's never different. It's never substantially different. What does it mean? It means that the judge or the arbitrator actually confirmed the decision of the dispute board. So recapping, not only we have few dispute board decisions being subsequently litigated or arbitrated, but when we do, the majority of the times, 44% or 35% in this case, rarely, but the majority of the time, we have those judges and those arbitrators confirming the decision of the dispute board. So saying that the dispute board did get it right. This brings a lot of credibility to the dispute board process, and it speaks a lot to the effectiveness of the dispute board resolution. I want to introduce the next topic by the next graph by mentioning a very specific function of the dispute board members, which is not only to resolve the dispute, but also to assist in avoiding the dispute. As we have seen in the latest edition, the 2017 edition of the FIDI contracts, the dispute boards are no longer dispute adjudication boards, but they are dispute avoidance and adjudication. So this increasing importance of the role of the dispute board to help prevent the disputes. We were very interested in that specific role when preparing our report. And so we asked questions also about the effectiveness of the dispute board in avoiding disputes. One of the questions that we asked here was, how often were dispute avoidance measures adopted by the dispute board? 25% of the respondents, the individual respondents in this case, said always. Another 25% said very often. And then smaller amounts, 20% said occasionally, 14% very rarely, and 15% said never. Still, we have 50% of the individual respondents that have been practicing dispute boards at least once in the past 6 years, who say that dispute board members have always or very often been carrying out this role of helping avoid disputes. We also have this data on what are the commonly adopted dispute avoidance measures. We have, for example, conducting regular project meetings to discuss progress, challenges, and potential issues, encouraging communication and collaboration among project stakeholders, identifying any emerging issues or potential conflicts during site visits. So as you can see, every of these measures, they deal with a dispute board that is actively present in the job site, that is actively communicating with the parties, and that is trying to anticipate any problems, to be able to resolve them, to be able to tackle them from a very early moment in order to avoid having it reach the point where the dispute board actually has to issue a decision. This role of measures, it's obviously not exhaustive. We also gave the parties the option to say what other measures have been implemented, and in the report we have that information. Every other answer that was provided on what other measures have dispute boards been implemented for dispute avoidance. One last data that I wanted to bring here today regards the result of the implementation of those measures. And what I mean by this result is, after all of these measures that we saw on the previous slide were implemented, what happened to this potentially emerging dispute? And here, I'm very happy to report that 45% of the individual respondents said that the dispute was completely avoided. So it didn't even become a dispute. At the same time, we have 41% of the respondents who said that the scope of this dispute was significantly reduced, which is still a positive outcome. 27% said that the scope of the dispute was relatively reduced. And then we have smaller percentages indicating that the scope was minimally reduced or that the dispute remained the same. What I mean to show with this data, and again, I must emphasize that this is only a very small window of all the data that we were able to gather with this report, is that there have been a lot of dispute boards implemented around the world. There are very different types of dispute boards. You will be able to see on the report, for example, which dispute boards have one member, have three members, what is the nature of the decision, how long did the procedure last, if the dispute board decision was a mandatory condition for subsequent proceedings or not. So we have all kinds of dispute boards. But when we put all of those different kinds together, you still have good numbers on the effectiveness of dispute resolution, on the effectiveness of dispute avoidance, with a relatively low cost when compared to the benefit of actually avoiding a dispute. And when this dispute does escalate to a subsequent level, litigation or an arbitration, you still have that decision confirmed. You're likely to have that decision confirmed by the judge or the arbitrator. Of course, that the work with this report, it doesn't stop here. Our main goal was just to provide the data, and I think there's a lot to be built upon in relation to this role, to everything that was reported here. I understand that it is a lot of information. I feel like I just spent 20 minutes talking to you about numbers and percentages. So I would really like you to invite to read the report. We had a fantastic steering committee helping you with the production of this report, including Jeremy Glover. And our goal is to create discussion. We want people to talk about what could be better in dispute boards and to use concrete data to be able to improve the system, which, if I'm not mistaken, is something that has been already happening in the adjudication world. But I don't want to take more time than I should have, nor still the spotlight from Claire, who's going to speak about adjudication to you in a minute. I'd be happy to answer some questions at the end if you have any. Also afterwards on the report, but for the time being, I am handing it over to Claire.
Thank you very much, Raquel. Hopefully towards the end of this, we can have a bit of a discussion about what the data and dispute boards could bring to the domestic context and adjudication and vice versa, because it's quite interesting to compare what's going on in the UK in adjudication trends and our statutory adjudication process with the dispute board process. So I'm basically going to give an update on the third annual report into construction adjudication here in the United Kingdom. It was written by Professor Nazini, soon to be an honorary KC, and Alexander Kalitz, who's another research associate at King's. And I had pleasure on serving on the steering committee. As I said, this is the third annual report that King's have produced into adjudication in the United Kingdom, and it builds on historic reports that were commissioned by the Adjudication Society going back about 15 or 20 years. I should just say, for I know we've got a lot of international people, but here in the United Kingdom, adjudication is a statutory process provided for by the Housing Grants Act. I know that is commonplace now across the world in various jurisdictions, and it provides for adjudication where there is a crystallised dispute for construction contracts, with a few exceptions. So how did we get the data? What is the data for this report, and what does it show domestically that may be different or similar, depressingly similar in some cases, to the international position? So there were two questionnaires sent out. One was addressed to the adjudicator nominating body, so the people who commonly have lists and people go to appoint adjudicators where they can't be agreed. 10 AMBs replied, and these are some of the biggest ones are listed below. So every major AMB in the country responded to this questionnaire and gave their data, which is obviously key. Interestingly, the number of referrals to AMBs had increased 9% in 2024 compared with 2023, which would at least suggest that, unfortunately, disputes in this country are increasing, perhaps with economic stresses increasing as well. A second questionnaire was addressed to individuals involved in UK statutory adjudication. 166 individuals replied in this, which is slightly down on previous years, but still enough to get meaningful responses and meaningful data. So I thought it'd be quite interesting to look at a comparison of leading causes of disputes in this country, specifically compared with internationally. Inadequate contract administration is very, very high up the list in the UK, 50%. That's 27% in the DB survey. So the UK is doing particularly badly on contract administration if you compare like for like. And lack of competence of project participants is a hot second at 42%. That has been picked up by our TCC judges in the forwards of all the reports, and unfortunately remains a depressing characteristic of the underlying causes of disputes. Exaggerated claims, changes by clients are also there. Changes by client, interestingly, in the DB one was 42%, comparing with just 30% here. And also inadequate design documentation is further down the list in the UK compared to internationally, where it was 26% in the DB International Survey. So some interesting differences, as well as some depressing similarities. I should also emphasise that there were other types of disputes that were flagged by respondents. So disputes about formation interpretations of contracts, delays to work in EOTs, negligence about qualities of inspections. That's probably a particularly hot topic in the UK here with the Building Safety Act. And other people made the observation that in terms of contract administration, people are too scared quite often, or don't want to rock the boat by issuing the relevant notices right at the beginning of the project, because they don't want to damage relationships. Of course, those can then develop into disputes themselves, which is part of the problem in contract administration. Common categories of claim. Now, here in the UK, as I said, we have statutory adjudication, and that comes with very tight payment certificate and pay less notice rules. If you miss the deadlines for those as an employer or a contractor as against a subcontractor, you will have to make payment of the amount that was notified to you by the contractor, essentially. So you can then enforce that by what's something called a smash and grab. And linking back to contract administration perhaps not being what it should be in this country, 63% of adjudications carried out in this country based on the respondents were smash and grabs. So they're technical payment disputes rather than the underlying. So as ever, get your paperwork in seems to be a hot message on that front. True value disputes, both in terms of final accounts and interim payments here in the UK, seem to be higher up the list when compared to the international topics. And equally, extensions of time and loss and expense, which were higher up the list internationally, are further down. But obviously, they would also often be a component of the final account dispute or the interim value dispute. So some interesting similarities and differences again. So value for claims, I think much lower generally here for statutory adjudication. We've got the most common value, if you can see from the graph, and again, I apologise for the slides being perhaps a little bit difficult to read, but there will be copies of these available which you can zoom in on. And equally, there's some, the report is on the King's College website, so you can read those. So the most common value is between 125,000 and $500,000. That's obviously relatively low, but depends on the value of the project as to how important that is to the people in question. And then 1% is between 40 million and 50 million. So this is a statutory process that is technically meant to take 28 days, although it's pretty much always extended in my experience. But it's still dealing with some very high value projects here in the UK as well. A drop in claims worth 5 million and above compared to the previous year report. So obviously with the number of respondents, it depends who's reporting and who's responding as to whether that makes a significant difference or not. So in terms of costs, typical hourly fees, most were between the £301 and £350 range for their hourly fees as an adjudicator. Some outliers at both ends. Obviously, for very high value or complicated disputes, you might want to get somebody who has a higher rate, maybe a KC if it's a legal issue, and equally some lower ranges. But that's sort of the ballpark figure you're looking at for an adjudication, an adjudicator here. I should note that a lower rate doesn't necessarily mean a lower bill in the round, but that's again on personal experience rather than the survey. Adjudicator fees, again, I should emphasise, because this is statutory adjudication, it excludes legal and expert costs. So this is just the adjudicator fees themselves. The legal costs associated with this project, this process, are irrecoverable under the housing grant. They lie with the party bringing the claim, which is obviously an important consideration when you're thinking of starting one. But a range, but the 20 to 30,000 pound for dealing with a typical dispute is sort of the ballpark, and I think that's around the 50-hour mark if you take the average hourly rate for dealing with a typical dispute. So what happens next? Again, I thought it'd be interesting to compare and contrast what happens with adjudication here in the UK. Statutory process with the dispute board process to the extent they are comparable. So percentage of adjudicated disputes that are referred to litigation or arbitration in the past year. So you go through the adjudication process, how many of those then go on? Well, the good news is 52%, it stops then and there, none, which is obviously very high levels of compliance with an adjudicator's decision. Now, I should say that a statutory adjudicator's decision here in the UK, once is binding on the parties temporarily until it's sort of reopened. So it's not, this wouldn't include non-binding recommendations, which Raquel was describing earlier. And it's not voluntary compliance in that sense. You are meant to be obeying these decisions anyway. It's just you may have to enforce them in the court if people decide that they don't want to do that. And 18% said that less than 5% of cases were referred to litigation or arbitration. So this is, on the face of it, a very successful process. It's nipping a lot of disputes in the bud in that they don't have to go further to litigation or arbitration. The adjudicator makes the decision and that's the end of it in a lot of cases. So if people don't just comply with the decision, they don't pay up, you then may have to enforce that decision for a summary process in the TCC. And King's also did a very good job at analysing the case law that comes out of the TCC to look at what sort of issues are happening and also the percentage of judgments that are enforced. And I should say these are only reported enforcements. A lot of the time there isn't a judgment to a published judgment. So this is reported decisions or judgments. So lack of jurisdiction of the adjudicator is the main reason that somebody might be saying they're resisting enforcement. Then you've got breach of natural justice at 29%, and both lack of jurisdiction and a breach of natural justice, sort of a hot second in terms of reasons for resisting. But jurisdiction is the key one for adjudicators out there. You've got to be very careful to make sure you'll have the jurisdiction. It is a crystallised dispute, etc. Successful grounds for refusing enforcement. Again, the main one is lack of jurisdiction. That's 22, and then breach of natural justice, and both natural justice and jurisdiction 10% each. So success rates for grounds refusing adjudicated decision. The TCC has a very strict, we will enforce this unless there's an obvious lack of jurisdiction, breach of natural justice issue, etc. That is a theme that's run since this process started, and that is reflected in the results. So 77% of adjudication enforcement, 70% of adjudicating decisions that went to enforcement were enforced. It's very difficult, as a generalisation, to get a decision overturned or set aside by the TCC. They definitely have a very pro-enforcement rate in terms of decisions. In terms of satisfaction, there is one topic that is often debated at the annual Adjudication Society conference here, and generally amongst practitioners, and that is actually complaints. Now, the complaints received by the AMB, so they're the people who have the lists that you can go to get appointments for adjudicators, are very low, and they have been for years. And there's always a discussion about why they are so low, because I think certainly party representatives feel they are almost too low and don't reflect the actual satisfaction. And again, that is not a finding of the report. It is based on discussion around this topic. There was only one complaint to REBA made last year, 11 to RICS, and I think it says one of those was upheld for RICS, and then the other one at the time was pending for REBA. So those are very low numbers of complaints. There's no getting around that. That is low, and it has been subject to discussion, because I know sometimes people feel they can't complain because there may be an issue down the line if you get the same adjudicator again. But on the face of it, based on the stats alone, that's obviously a healthy low number of complaints about the process. And then finally, a hot topic for me, diversity in terms of adjudicators. We launched the equal representation in pledge for adjudication in the UK probably about 2 or 3 years ago now. And most of the AMBs have now signed up to that pledge. We have a slight increase in the number of female adjudicators. Some AMBs have better percentages than others. TEP bar is currently the highest, 20%. But AMBs are now tracking that much more and trying to make the panels more open to applicants on an objective basis. So putting in clear qualifying criteria and exams processes in place, so that it's not such a sort of smoke and mirrors process as how you can get on these AMB panels and become an adjudicator. So with that, I think we're going to have hopefully a bit of a discussion, some compares and contrasts of the international and domestic adjudication scene. Jeremy.
No, excellent. Thank you both very much. Thank you, Claire. Thank you, Raquel. We've had a number of comments as opposed to questions, and they've all been very complimentary of both your presentations and the detail that's clearly contained in those reports. But just starting with one, Claire, you were talking about the attitude of the TCC, the courts in England and Scotland, to be fair, very pro-enforcement of adjudicator decisions. One of the questions that's come in, and I don't know if the research or how the research looks at this, Raquel, whether there's a similar mentality by courts when it comes to the enforcement of dispute board decisions. I suppose that might be courts and tribunals. Because as Claire was saying, it's very much that the sort of courts will look to enforce adjudication decisions. I wonder how that was reflected in your research, if that was something that you came across.
Thank you, Jeremy. Actually, enforcement is one of the topics that we looked into in our research. We looked at frequency of enforcement of proceedings, method of enforcement, and enforcement rates. I have to say that most of the respondents reported that they have never been involved in enforcement proceedings. I think, and as Claire mentioned, this is my opinion, this is not in the report, but I think that is also due to a lack of uniformity and a lack of clarity in terms of what can I do with a dispute board decision. I think that anyone who has ever looked into dispute boards has come across the Macedo decision 1 and 2, and the whole, we could have definitely a webinar just about that case if you haven't already. But there is a lack of clarity in terms of what can we do with that decision. So one of the questions that we asked for the people who were involved in enforcement was, how do you do it? And most people reported that they have participated in enforcement of dispute board decisions through arbitration. So they go to the arbitrator and they say, please issue an order enforcing this decision. This can be done in a final award, in an interim award, and sometimes even in emergency arbitrations. But this is what the report showed. Again, the numbers are very low, but there is data there about enforcement. It's not conclusive, so it tells me that it has been happening. We don't really understand why. It feels like it's turning towards arbitration, but that is the scope for yet another full report.
I'm certainly another full report, I'm sure. And you've highlighted one of the clear contrasts. I mean, a lot of the international projects where they have dispute boards, if there are issues, they will go to arbitration, and strictly arbitration is confidential, so we don't know what happens or doesn't happen. Whereas obviously in the UK, certainly the decisions tend to go for enforcement to the courts, and then the judgments, when there are judgments, are out in the public arena. And we've had a sort of more legally based question. Now, Claire, you were very clear when you were talking about statutory adjudication under the Housing Grants Act. And yes, there is the alternative of contractual adjudication. Now, that might lead to dispute boards. It might sit on projects to which the Housing Grants Act strictly doesn't apply. So we've got these two statute and contractual adjudications. Question was really wondering the extent to which you can bring jurisprudence about the statutory adjudications from the UK Housing Grants Act to support decisions and opinions when it comes to dispute boards, which is, I mean, to me, that's quite it's an interesting question. And sitting here personally as a sort of UK lawyer, the immediate temptation when you get these questions is you think, oh, well, the TCC or the Scottish courts have said this. And to me, one of the things you need to do is remember the law of the contract that you're actually operating under. And quite often, you know, can you actually apply the law of England and Wales and things that have happened there to the international projects? And sometimes the way to do so is by way of example, and try and use the logic of a decision to that the English courts may have come up with to the dispute board process, whatever may be happening. But I don't know if either of you had any thoughts on that particular issue.
Raquel, do you want to go first, or yeah?
No, I was going to say, go ahead.
I think obviously it depends on the governing law. If you've got English governing law and everything is firmly seated in the UK, then I suspect the TCC case law would be used by those seeking to enforce a dispute board decision where it's been followed, where the process has been followed, and the parties are clearly provided for it and there's nothing untoward in that process, I can't see why that wouldn't be followed. Internationally, obviously, if it's a common law country, you'd hope that maybe you could use some of the English case law maybe as guidance on that process to the extent it's helpful. If it's a different governing law, then obviously hopefully they will have interesting decisions and they'll have different approaches to them. But I think dispute boards internationally are becoming increasingly recognised, and you would hope that the courts would see that the parties select that process for a reason, and enforce it accordingly.
Yeah. Raquel, did you have any comment?
No, just actually a very brief comment. We don't have that specific information on the dispute board. So what I can contribute to this is most of my experience is in civil law countries, and I have seen a lot of dispute boards now in Brazil. The discussions are mostly technical as opposed to a legal issue. And in Brazil, we don't have specialized court like the TCC. Still, I wouldn't see any restraint in resorting to Brazilian cases and how the judge has decided if Brazilian law were to apply naturally. So I think it's a difficult balance when you talk about international cases, especially if you have more than one law applying, which can happen with dispute boards, and you have to make sure that you have that expertise within the dispute board. So that is also a factor that I think should be counted in.
Okay, no, that's really helpful. That's really helpful. I think one of the things you were talking about, Raquel, you're mentioning the role of development banks in relation to the dispute boards, and someone was really wondering the degree to which development banks do have influence or oversight of dispute boards. I wonder if that was something that you had covered.
It actually is. Our report is divided into sections depending on the category of the respondents, and the part 3 of the report, let's say, only shows the answers given by funders, these financial institutions. We did ask if these financial institutions, for example, have a policy for including dispute boards in projects in which they finance, which they do. Of course, then the implementation of the dispute board will depend on the policy. Some policies are a specific cost of the project has to be reached, or a specific procedure has to be adopted, so forth and so on. We also ask questions about whether they are involved in the actual dispute board procedure, and most of them answer that they are not. But still, every funder had an opinion about dispute boards and how they should work. And one interesting thing that comes to my mind regards their involvement in terms of how these banks can actually foster the use of dispute boards. And you know this because this is something that we have discussed in the past. Of how it can be an obstacle for the parties to implement a dispute board when the cost of that dispute board is not factored in the tender process. And one research that we came across while preparing this report is really interesting. So the JICA has a dispute board manual that they issued in 2019, which has a very interesting phrase. They say that JICA recognizes the dispute board as a mechanism for sound contract management as opposed to conflict dispute resolution. And if you actually look at different documents, standard documents for investment banks, they do consider dispute boards a contract management tool. And the next step would be to actually factor that in as a tool to be implemented in the contract, so to consider the cost of that within the tender. JICA does it. I am not aware of any other dispute of any other financing institution doing that, but that would definitely constitute a very relevant involvement in the financial institutions on the fostering of the use of dispute boards.
Okay, that's excellent. And what was particularly good was that you inadvertently touched on one of the other questions that had come in, asking about advice for, how do you recommend the use of dispute boards to the industry in general? And what was particularly helpful when you focused on costs, because one of the concerns about many parties, well, dispute boards too expensive. And I know you had some slides on that. And I think one of the ways that we can actually, recommend to the industry is to use some of the conclusions that you have addressed as to the costs, and look for ways to how the costs can be included perhaps within the initial project budget, as you've just suggested, is quite a good way of stopping parties worrying so much about the overall expense when they're at the initial part of the contract during the procurement stage, whereas we know that sort of when you get to the end of the project and then you actually see the value of the dispute board. But one of the interesting things, I mean, some of the projects that JICA might do, or some of the you might get in some of the civil countries, is sort of the use of dispute boards on public works contracts, and that's not something you see so much, if at all, in the UK. And that might be, Claire, because of the use of statutory adjudication. When I say use, well, you have to use the statutory adjudication. And I think one of the places where you don't see that many dispute boards being used is the UK. And I was really wondering, Claire, I mean, is there a place for dispute boards in the UK?
Well, I think the from the dispute board report suggests there probably is for big projects, because they're clearly getting in there early and preventing the disputes crystallising in the first place. And if we can do that more for those sorts of projects in the UK, particularly ones that are subject to statutory adjudication, it strikes me as being quite helpful. I know the NEC now has sort of a different option for dispute boards, but that's more for use internationally. So I just wonder if there's scope to sort of try and be compliant with both, essentially. Maybe you get the sort of FIDIC mechanism where you get somebody who makes a recommendation and then they go the next step and they can do the adjudication as well. You'd have to think quite carefully on the case law about bias and things like that with statutory adjudication and how that worked. But there seems to be a lot of evidence that these are preventing disputes in the first place, which is obviously good for relationships and saves money and time. So yes, I would have thought there is scope to think about how we can get the best out of both worlds, essentially.
Okay, cool. I'll ask you to comment in a second, Raquel, but I just wanted to point out to everyone the obvious what's on the screen at the moment, which are the links to the two reports. If you want to sort of find out more and actually read the reports themselves, the links are currently on the screen. Raquel, I wonder if you had any comments on the, should we be using DBs on public work and contracts in the UK?
Should and could may create a very significant distinction in your question and in my answer. Speaking from what I've been seeing in Brazil, dispute boards have been growing a lot in Brazil, and dispute resolution in general, alternative dispute resolution methods in general, have been growing a lot in Brazil as well. What I've been seeing there is, yes, they have been using dispute boards for projects and contracts with the state, but there is a key element that it's essential, which is to have very clear rules about how this is going to go. For example, specifically in Brazil, recommendations would not fly. Nobody would comply with recommendations, because if the decision is coming from a state and they need to spend money on a variation, on an extension of time, they need to have a binding decision to justify that. So you have to have that specific framework of the dispute board for it to work with public institutions. And on top of that, what I would say that it may also depend on laws enabling that. So we have had some guidelines in Brazil saying that it is allowed, and people started to look at dispute boards. But in specific states where you don't have that, dispute boards are inexistent. So it comes from very different places. It may come from the state, it may come from the law, it may come from the financing institution. Dispute board can arise from different sources, I would say.
Okay, no, I mean, that's very interesting. And I think from a UK point of view, it's worth pointing out that the Construction Playbook, which is the government's procurement guide, does actually acknowledge the value of dispute boards. So I think that, you know, from those who are putting together the big public works contracts, you know, dispute boards are definitely up there and being recommended by the government. And there are contracts, I think the JCT and the CIR do have a contract where you provide for the use of a DAB who can actually also act as the statutory adjudicator should that be necessary. But I fear, unfortunately, that we've come to the end of our time. We've raised a number of topics that we can actually carry on discussing for quite well into the afternoon. But I appreciate that our slot has come to an end. So I'd just like to thank you both again, Claire. Thank you, Raquel. Thank you very much for your incredibly interesting presentations. Like I say, you should have access to the slides. You can look at the reports at your leisure, and it just remains for me to invite you to come along to our next webinar in March, where we will be looking at the Building Safety Act and particularly the use of remediation contribution orders, or RCOs. So thank you all very much for your time and contributions and very interesting questions, and we look forward to seeing you all again in March. Thank you and goodbye.
Thank you.